All right, good afternoon, everyone. This is Austin Smallwood, your SCR Director of Legal and Regulatory Affairs. Today, we're going to be going over the upcoming changes to the SCR sales contract, SCR Forms 300 and 310 that will be taking effect on June 13th. We are not going to be able to take any questions today due to the amount of volume. If you still have any questions after the conclusion of this webinar, your legal hotline team is more than happy to answer those questions, but I would ask that you hold any questions till the end of the webinar. Okay, so I did want to make the following disclaimer. This webinar is being recorded on April 28th, 2022, and is based on the upcoming forms change set to take effect on June 13th of 2022. The contents of this webinar are intended for SCR members only. Any and all legal guidance that is given during this webinar is of a general variety and is subject to change based on particular circumstances, subsequent forms changes, and/or subsequent license law changes. Attendees and viewers of this webinar are advised to make sure that they are always using the most up-to-date contracts and contact their a brokerage attorney or the legal hotline with any legal questions. If after today you are looking for this presentation, there will be two ways to find it. It will be on our SCR Facebook page as well as our SCR YouTube page. We are not going to be able to, for legal reasons and to protect you from the unauthorized practice of law, we'll be able to provide copies of the slideshow for you today. But again, the legal hotline team will be happy to answer any questions you have at the conclusion of the webinar. So here's sort of the outline for today. It's going to be three main sections. The first is we're going to do some background as well as the pros and cons of the forms change. The second part is we're going to go over some best practices for you when using due diligence. And then the third is we're going to go over the top 10 issues that may occur, as well as some possible solutions and outcomes should those issues occur. So the first thing we're going to do is we're going to go look at the actual forms change itself. So this is the draft version of the contract that is available on the SCR website. And this is what the form will look like, so minus the draft watermark on June 13th. We did not make any changes to the contract except for the highlighted portion, and all we did was delete repair procedure and as is. No other section of this contract was changed, and no additional verbiage was added. So actually, this will result in you having a shorter contract. So the only change is to paragraph 8, as highlighted here. This is not new verbiage. This is the exact same due diligence language that is in your current contract and has been in the contract since the due diligence was a separate addendum in 2019. And there will just be two blanks for you to fill out on this section. The first will be that your due diligence period begins upon an effective date and shall expire at 6 p.m. on a hard date. That's going to be your due diligence period, whatever's agreed upon by the parties in that blank. During that due diligence period, the buyer can do any and all inspections that they deem necessary. They will then send a repair request to the seller. The seller can then choose whether or not to accept the repair request, counter the repair request, or just ignore the repair request. And then based on that, the buyer will then have a couple choices. If the seller agrees to their repairs, then we're under contract going forward to closing. If the seller counters, then the buyer can choose to accept that counter, or they can terminate by delivering notice of termination, the termination fee. Or if the seller doesn't respond, then the buyer can either buy the house as is, or they can terminate by delivering notice of termination and the termination fee. That brings us to the second blank right here, which is during the due diligence period, the buyer may unilaterally terminate this contract only by delivering to the seller both the notice of termination and a termination fee of blank dollars. That is an amount of money that will be negotiated by the parties and will be hopefully is there to try to level out whatever is put in this first blank. So I've gotten calls about this form change that this is either favors buyers significantly or favors sellers significantly. It really depends on what the parties put in these particular blanks. So if you have a very long due diligence period and a very small termination fee, that's going to favor the buyer. If you have a very short due diligence period and a large termination fee, that's going to favor the seller. The key is to try to find something in the middle that both parties can live with. But do note where it says in termination that is only valid termination if you give the notice of termination and the termination fee. One without the other is not a valid termination. Failure to deliver both of those by the due diligence deadline will result in an as-is contract in regards to repairs. So that is the only actual change to this contract. So the next thing we're going to go over is actually show you what the repair request looks like and make sure you're using that correct form, and then over the notice of termination and the release document. So this is a repair request. This is SER form 525. This is the form that we recommend using when sending your repair request. Make sure that you actually list out repairs on this section here. This repair request is where you're also going to have sections in here to dictate about when repairs are going to be done, cure periods, rights for reinspection. Repairs do not have to be completed during the due diligence period, but repairs do have to be negotiated during the due diligence period. So I did want to clear that up. Under due diligence, the most important part of this section of this form is going to be paragraph 2. This does state that when the repair procedure is agreed upon by both parties, that sunsets your due diligence period. So the reason for that is if the buyer sends 10 repairs they would like done and the seller signs it, it's not fair to the seller for you to then come back with 10 more repairs the next day. So make sure when your buyer sends this, that your buyer is perfectly happy that if the seller was to sign this 1 second later, they would have gotten any and all repairs that they wish to have done with the property. So if you have a 30-day due diligence period and on day 1 you send this repair request and the seller signs it, you are done with due diligence. You have forfeited your remaining 29 days. Also, I would make note of this expiration here. I would always make sure that my repair request expires at least 48 hours prior to the end of due diligence. That way, if the seller doesn't respond or to your repair request, your buyer has a couple days to try to pivot and figure out what they want to do there. I would not have this expiration date match the due diligence period because you do not want to have your buyer waiting around until 5 o'clock the last day, wondering if the seller will respond or not. You want to have some time for your buyer to pivot based on whatever the seller has decided to do. So the next form we're going to go over is the notice of termination. This is the form that should accompany the termination fee if a buyer chooses to terminate during the due diligence period. If you'll notice in here, the words earnest money do not appear. So you should not negotiate earnest money or discuss earnest money in this form. Earnest money can only be discussed through the release agreement, which will be the next form that we mention. But this form, in conjunction with the termination fee, is the proper way to terminate. You'll notice that there are buyer and seller lines on here. The reason is because this can be used for other purposes during the contract, but for due diligence reasons, this only needs to be signed by the buyer. This is a unilateral communication. There is no requirement that the seller sign this. Simply the buyer providing this to the proper notice address or email, along with the termination fee by the end of the due diligence period, is a valid termination under due diligence. Now, if you're wanting to discuss earnest money, the proper form to do so is this release agreement. This is SER form 518. South Carolina license law requires that if money is held with a real estate brokerage account, for earnest money to be dispersed, it has to be done either through a mutual agreement of parties or a court order. This is your mutual agreement of the parties. So if I was the buyer's agent and I was submitting a termination, I would make sure I got that termination fee and that notice of termination there well in advance of that deadline. I would also submit at the same time my release agreement. For no other reason than that is probably your best chance your buyer's going to get their earnest money back when the seller's already holding a check with the buyer's, the buyer's already written the seller a check at that point. So this form does require both parties' signatures though. So if this is only signed by one of the two parties, it is not valid. But if it's signed by both parties, they can essentially take this form to the escrow agent and say, please disperse funds in accordance with this document. So now we're going to go back to the PowerPoint, and hopefully this will answer many of the questions that you all have. So one of the main questions I've been getting is, how did we get here? Why are we making this change? What was the process for going to a strict due diligence contract? So this has been many years in the making. This has been something that we've been discussing in Forms Committee for a number of years. If you remember in early 2020, when we made the forms change we did then, we removed the due diligence addendum and moved due diligence into the main contract. Wanted to see how that went, didn't have any major pushback to that. So the Forms Committee in early 2021 did make a motion to go to a strict due diligence contract. We then pretty much spent the remainder of 2021 discussing multiple versions of how to do this between the Forms Committee and the Executive Committee. Many hours were spent sort of exhausting every possible option and finding something that worked best for buyers and sellers, as well as membership for across the state. Motion was presented ultimately to the board of directors in December to go to a strict due diligence contract, but that motion was tabled until the February meeting, until they could have an in-person meeting to discuss that. The motion was ultimately passed at the February 9th board of directors meeting. And as I previously mentioned, that forms change will go live on June 13th of 2022. I did want to make a note when we say that forms change will go live, that means it will be on our website, zipforms.loop, DocuSign, wherever you currently get your forms. We will take care of that. Any contract that you're engaged in prior to June 13th will still be fine. They'll be grandfathered in. But if you were to start a new contract on June 13th and you go to your preferred forms provider, that form will be there. You will not need to update this yourself. That will be done on our end without you having to do anything. So what are some pros of this form change for a buyer? The first would be, this is going to allow the buyer to ask for anything that they would wish. And it's going to allow the buyer to conduct any inspections that they deem necessary. So you're not going to have the process that you had under the repair procedure where there was some seller paid repairs, some stuff that was not seller paid repairs. You would have to advise your buyer, well, you can ask for this, but the buyer doesn't really have to consider that because it's not a seller paid repair. This sort of opens it up. If the buyer thinks it's necessary, if the buyer needs to look at something or want something inspected so they can feel comfortable buying a property, then they're able to do that during the due diligence period. This is going to avoid them having to get subject matter experts to avoid determining what's operable. I know a number of you have probably had that issue where what is an operable HVAC system? Is that one that simply turns on, or is that one that should be operating at peak performance? Under due diligence, the buyer could simply have an HVAC inspector come out, review the unit, and then ask for the repairs to be made that are in accordance with what was recommended by that inspector. So what are some pros for the seller? It's going to make the repair process much cleaner, as opposed to under repair procedure where there was a deadline for the buyer to submit repairs, then a deadline for the seller to respond, and then there was a 2 calendar day window afterwards to negotiate. It's much easier under due diligence. We've got to be completely done by whatever date the parties put in paragraph 8. This could allow for an easier path for them to put the house back on the market, because once the buyer has submitted to them a notice of termination, they have received word from the buyer that that buyer does not intend to move forward with the contract. Therefore, the seller could put the house back on the market. Now, ideally, when the seller receives that notice of termination, they'll sign the release agreement, clearing up any earnest money disputes, and that house will be able to go back on the market without any possible issues. But if the parties refuse to sign the release agreement, then you still want to advise your seller to talk to their attorney before putting their house back on the market, because there could be some issues with earnest money, whether or not they need to make any disclosures, add any addendums, but they would still be able to put the house back on the market. They would need to get legal guidance prior to doing so. And then, of course, the termination fee can be attained. If the buyer decides to terminate during the due diligence period and the parties have agreed to a termination fee, then that termination fee has to be paid. What are the pros for you guys on this form change? So you no longer will have a debate of which repair option to use. There's no more, well, I prefer as is, or I prefer repair procedure, or I prefer due diligence. There's only one option for you to choose from. So it's due diligence. Only one deadline for you to keep track of. Now, we're going to talk throughout the day of some sort of internal math that you want to do on this, but if you kind of keep in the back of your mind, the overarching thing of by this date, our due diligence period is over. So we've got to be completely done by this date. There's a lot less tracking that has to go on. No longer will you have a debate on what's operable or what's structural or whether or not this is a seller paid repair, because it's simply what does the buyer want fixed? What is the seller willing to fix? Those are your sort of new criteria. And this is going to keep you from practicing outside the scope of your license. You're no longer going to have the issues of clients going, well, hey, isn't this what an operable system should look like? Isn't this a health or safety concern? Isn't this something the seller should have to fix? Now you can simply tell your buyer, put this on the repair, put it on your repair request. We'll see what the seller has to say. And if you're not happy with the seller's response, then we have a way for you to terminate under due diligence. So just to be straightforward with you guys, there are some cons, but you'll notice a lot of these cons for one of the parties is actually a pro for the other side, which shows that it's a pretty balanced approach. So a con, the buyer can walk for any and all reasons. Now, that is obviously a pretty big pro for the buyer, but it is a con that your seller to be aware of, that the buyer, should they pay that termination fee, can walk for whatever reason they would like. There is no contractual deadline for the seller to respond. So your buyer needs to be aware the seller may not actually ever even respond to your repair request, which is, again, why we want to make sure that we have that 2-day cushion from when our repair request expires and when the due diligence period ends, so our buyer can pivot should that occur. The buyer could have to pay a termination fee. But again, that was one of the pros on the form for the seller. The seller could give the buyer a free look if there's no fee agreed upon. If you guys agree to a 20-day due diligence period and put $0 as a termination fee, and the buyer decides to walk on the 19th day, and the seller goes, well, hey, I just gave the buyer a free look, and let them take my property off the market for 19 days without paying me anything, you'd be like, yes, that is exactly what happened. That's why it would be likely in your seller's best interest to make sure that there is some fee there, so at least they can be compensated for their time of taking the house off the market. And there's no longer a distinction between seller paid repairs and other repairs. It's sort of everything's on the table at this point. If the buyer wants it fixed, they need to put it on the list, and then they'll see what the seller has to say. But there's no, this system has to be operable. The roof has to be free of leaks. It's really what the parties can negotiate is the entire list. Okay, so now we're going to get into some best practices, sort of how would we recommend filling out these blanks or some issues that you may occur, some internal processes you may want to look at. So the first one would be figuring out that length of the due diligence period. So what do we need to put in that first blank in paragraph 8? The first thing to remember is that no two contracts are the same. So there shouldn't be any sort of standard, well, hey, we're always going to put X number of days, because each transaction is going to have different factors that affect the time period. If it's a very competitive market, you may not be able to put as long of a time if it's as opposed to a property that no one's looked at for months. A house that doesn't need a whole lot of repairs is not going to need as long of a time period as a house that needs a lot of work. Some buyers are more comfortable making repairs on their own than other buyers. So there's just a number of factors that you're going to need to consider. So that's why it's going to be important to have a frank discussion with your buyer and ask them, what are your expectations? Are you expecting a house that is, completely, you're not going to have to do so much as sweep when you move in? Or are you comfortable doing some repairs? Or what is your reasonable expectations for what this house will look like at closing? You need to assess how much competition your buyer's gonna have for the subject property. Again, if there are 20 offers on a property, you may not be able to ask for as long of a due diligence period as you would like if there were 0 offers. Or if you want that longer due diligence period, you may have to up the termination fee to balance out that increased time for due diligence. Make sure that you're putting an actual date at the end of due diligence. That's why we have parentheses dates. So do not write X number of calendar days or business days. You need to make sure that that's a hard date that can be found on the calendar. Also make sure that if you're negotiating this contract back and forth, that you're keeping track of that date you put in there. And if it subsequently needs to be changed, that you do so. Don't write where you think you're going to do 10 days on the front end, and now it takes you 5 days to negotiate the contract. You never amend that date, and now you've actually only given your buyer 5 days of due diligence. Consider if you're having delays in your market for getting particular contractors, that, hey, we may not be able to do a very short due diligence period because we won't be able to get this particular contractor that you want out there, this inspector. So you kind of got to be aware. And that's why, clients are hiring you for your market expertise of knowing how long that should take in your particular area. And that's going to, of course, vary from state to state, from parts of the state. So here would be my formula for doing an ideal due diligence length. So the first thing you would do is talk to your buyer. And once you've had that frank discussion, say, what all inspections would you like to have done? And then figure out what is the number of days it's going to take for us to be able to do any and all of those inspections. The next would say, sort of flip it and go, all right, now if I was the listing agent and I just received this repair request my buyer sent, how many days would my seller reasonably need to respond to that repair request? And then if you have an in-town or a local buyer, I would add 1 or 2 days. If you have an out-of-town buyer, I would add 3 to 4. And that would be sort of my recommended length for due diligence. But understand, of course, that's going to change based on each particular contract. So that's why, sort of a default of we always do this number of days is probably not the best approach. Okay. How much money should we put down for the termination fee? Again, a reminder that there are no two transactions are the same. There's going to be a number of factors that could change what that number is. We do not at SCR recommend a particular fee, but we would discourage you from doing a nominal fee like $1. There's sort of a legal fiction out there that we have to put some amount of money in this to make it valid. That is not true. If you put $1, all you've done is made a huge headache for everybody. Someone now has to drive across town to deliver a $1 check. Someone has to write a $1 check. Someone has to go deposit a $1 check. So if you're going to put an amount of money in the termination fee, at least make it worth everyone's time and effort. As what are some of these factors when we're talking about what could affect what you put in for the due diligence fee? the length of time, a 5-day due diligence period may not require as big of a fee as a 15-day due diligence period. Market conditions, is it a very hot market? Is it sort of a slower market? That's going to kind of change what the fee are. Is there multiple offers? If you're in, got again 20 offers, you may have to put a more competitive termination fee than if you're the only offer in town. And then, of course, the condition of the property. A property that is, move-in ready, has no issues whatsoever, may require a higher termination fee than a property that they probably expect that people are going to walk away. Make sure that you're reminding both parties that this fee is only going to be paid if the buyer terminates during due diligence. There's never a time where a termination fee will be paid outside the due diligence period. We'll talk about a few exceptions for that fee being paid during the due diligence period, but once you're outside the due diligence period, that termination fee will never be owed. Make sure that you're discussing with your buyer the severity of failing to timely deliver that termination fee. If they don't do that, if they don't timely deliver that fee, they're going to be in an as-is contract in regards to repairs. If they then decide to terminate anyway, they could be facing severe legal liability. So make sure that they're aware that this is not something that we should mess around with or joke around. This is a very serious matter. Make sure that they're aware that even if the seller won't agree to the repairs, the fee is owed. So even if they send, they go, everything I asked for is completely reasonable, and the seller doesn't agree to any of them, why should I have to pay the termination fees? Because that's what you agreed upon. That is your contractual obligation. You would have had to pay that fee if you'd wanted to walk away for whatever reasons you wanted to, and that's sort of the mutual promise there. So make sure that they're aware of that. So a couple questions that I would have for my client about when we're trying to figure out what to put down for the termination fee amount. The first would be, can you actually write a check for this amount of money? Don't put an amount of money that you don't actually have. That's going to be a huge issue. Don't have a buyer who goes, well, I'll put down a huge amount so I can win the contract, but I would never actually terminate this contract. And then they wish to terminate and they don't have the funds with which to do so. Remind them, hey, can you actually write this check on a moment's notice? You may decide, 48 hours prior to the end of due diligence that you wish to terminate, and we don't have time for you to try to move funds around. So you need to be able to actually write that check on a moment's notice. And then lastly, do you understand when and why you're going to have to pay this fee? That you're fully aware under what circumstances that fee would be owed, and that there's not really a lot of negotiation unless it meets one of these rare, few exceptions that we're going to discuss later on. So the questions I would ask the listing agent if I was the buyer's agent once this contract is ratified. First would be, is the seller's notice address? If you'll go to the last page or second to last page of your contract, you'll see where it says seller's notice address. That is ideally where you're going to put where the seller is going to receive that termination fee. 99% of the time, that's going to be the listing brokerage office, but make sure that, hey, your office was put as the notice address. That is where we're intending on bringing that termination fee. Is that a correct understanding of the contract? Yeah, follow up with that. So what are what are the hours of operation for your office? And are you guys expecting any office closures during the due diligence period? Don't have your buyer try to deliver a check at 5:30 on a Friday and then get there and find out that the office closes at 4 o'clock on Friday. So figure out that ahead of time. Don't wait till the last minute. Ask, will the listing agent be out of town during the due diligence period? And if so, who would be their preferred point of contact if you need to find out something, or if you need to coordinate dropping off of that termination fee? If your buyer is not local, you're going to probably need to discuss additional steps that may be needed for getting those funds to them. If the buyer is local, ask them who they should ask for when they go to deliver that termination fee in person. And then I would always follow up with this 48 hours prior to the end of due diligence to make sure that none of these previous answers have changed. So again, that's why I would have that repair request expire 48 hours prior to the end of due diligence. That way, at that point, the seller hasn't responded to our repair request. That's sort of your cue. Let me follow back up with the listing agent. Say, obviously, there's a chance we're going to terminate because there's only 2 options left for us now. I'm going to buy as is or terminate. Just want to make sure if we do terminate that I still know where to bring the check, who I need to ask for, your hours of operation, you guys aren't going to be closed, anything of that sort. So what is our SCR recommended method for terminating? So the first would be to make sure that notice of termination and that termination fee are both delivered by the 6 p.m. deadline. And I would not try to do it in the 5 o'clock hour. I would make sure that that is well in advance. I would not be worried trying to hope that we catch every green light, that we don't get caught in traffic, that there's not a wreck, things of that sort. I would not be trying to wait till the last minute, because at 6:01, your buyer does have it as his contract in regards to repairs. As mentioned, I would include with that the release agreement, which would allow for the earnest money to be dispersed if signed by both parties. If your buyer is local, we would recommend that your buyer actually physically deliver the termination fee themselves. That's one less hand that's touching the check. Now you're not going to be responsible if that's not delivered timely. Your buyer's not going to bother you now about, hey, have you delivered my fee? Have you delivered my fee? Because they will know, because they will have delivered it themselves. Have your buyer get someone at that notice address to sign that they've received the fee, and then have your buyer text you that, hey, I just dropped off the fee with whoever it is, and then you can follow up with the listing agent. I would if at all possible, I would avoid mailing that termination fee, because you want to make sure that that check is actually in hand by 6 p.m. on the due diligence date. So trying to, hey, we didn't have time to get across town, so we put it in the mailbox at 5:59. I wouldn't try to make that case. So if at all possible, avoid mailing the check. And if you're going to do so, make sure you're mailing that, days in advance of the end of the due diligence period. Buyer's agents, if at all possible, should avoid holding or collecting the termination fee up front, because once you touch that check, you're now responsible for it. So if it gets lost in your desk drawer, between your car seats, you put it in a file in your office. Your buyer then calls you 2 hours before they end the due diligence and wants you to go deliver that check, and you're across town or you've got another engagement. Now that's a huge liability on you. So if at all possible, I would avoid you guys holding that money. A reminder that termination fees should only be paid if the buyer terminates during the due diligence period. So that fee should not be prepaid, and you should not include that with the offer. If you attach the termination fee with the contract, you've sort of, as your buyer sort of already told the seller, hey, I probably intend on terminating this contract. I've already done half the work to terminate this contract. I've already given you the money. All I've got to do now is sign a one-page form, and I could be out of the contract. So it doesn't put your buyers in the best foot, putting their best foot forward at that point. So I would not give that check to the seller unless and until you're intending to terminate. Okay. So now we're going to go over the 10 most common issues that you'll see under due diligence. This is not to say that you're only going to see issues under due diligence, but I wanted you to be aware of these should they pop up or occur. So the first is going to be, what happens if the buyer fails to deliver the termination fee? So this would result again in an as-is contract in regards to repairs. The buyer would not have validly terminated the contract if they failed to deliver that fee. If the buyer then decided to terminate, they could face legal liability. And I do want to clear up, they would not simply be sued potentially for the termination fee. They could be sued for breaching the entire contract. They could also be susceptible to lawsuits by the brokerages. So that that little bit of termination fee that they didn't want to pay could end up being very expensive very quick. And I do want to note again, neither party is going to be automatically entitled to that earnest money. So even if the buyer doesn't pay the fee and they want to terminate, that doesn't mean the seller gets the earnest money. It doesn't mean the buyer gets the earnest money. Earnest money is going to have to be mutually agreed upon by the parties, or you're going to have to get a judge to tell you where to take that money. The second one will be, what happens if the seller never responds to your repair request? So this is completely within the seller's rights. There's no requirement that the seller even respond to your repair request. There's not any requirement under the current contract. I just want to make this clear to everybody that the buyer should not be waiting around for the seller, at 5 o'clock and go, well, I'm still waiting to hear from the seller. The seller may not ever respond to your repair request, and that's completely their right to do so. So that's, again, why you want to make sure that that repair request expires prior to the due diligence deadline. I would make sure it's at least 48 hours prior. The buyer can then, if the seller doesn't respond, they've essentially got two options. They can try to, they can buy the property as is, or they can terminate prior to the deadline by paying that notice to terminate, delivering the notice of termination and paying the termination fee. The buyer could also reach out to the listing agent and say, hey, is there a reason your seller didn't respond? Do they need more time? Can we try and negotiate an extension? But if the parties aren't interested in an extension, then you need to quickly try to move forward to one of those other two paths. So what happens if the buyer has to terminate the contract over financing? So I've mentioned a couple times that there are a few exceptions under which a termination fee would not be owed if the buyer terminates during the due diligence period. This is one of them. So a termination fee would not be owed if you're terminating under financing. I would, as the listing agent, make sure I actually got something from the bank showing that the buyer's financing was actually denied. I would not simply take the buyer's word for it. This would also apply if the buyer terminates under the appraisal contingency, paragraph 10, or the CL100 contingency, paragraph 11, or if you did have a buyer sales contingency, form 504. Now, you need to actually make sure the contract is contingent on one of those for this to trigger it. But if you were to terminate under a different provision of the contract during the due diligence period, that would not require a termination fee would be owed, because you would not be terminating at that point under due diligence. You'd be terminating under financing or appraisal or CL100 or buyer sale contingency. When the buyer terminates with this, again, does not affect the termination fee. You will never have to pay a termination fee if you're terminating under one of these provisions. And again, neither party is going to be automatically entitled to their earnest money. So earnest money problems. Hopefully for the last time. So earnest money can only be disbursed through mutual agreeing parties or a court order. So there is no automatic right to earnest money under due diligence. So if your buyer or seller asks you, well, I'm going to get the earnest money, right? The answer is going to be no, no, no. It's going to be mutual agreeing parties, court order. I would have them, if you don't already, have both your clients, both parties of the transaction, or your client sign SDR form 620. That is our earnest money disclosure that lays out for them what happens with earnest money. So if something goes wrong later on, you can say, hey, remember, it's already in your contract, but I had you sign a second form, making it even more clear what happens with earnest money. A reminder that earnest money is going to be separate and apart from the termination fee. So you should not write one check for both amounts. Your client can't go, well, we have $1,000 earnest money, $500 termination fee, I'll just write a $1,500 check. That is not proper. You also cannot slice the $500 termination fee off of the earnest money. Those are going to be two completely separate pots of money. If your buyer goes, well, why not? That just seems simpler. The easiest answer is the earnest money check is written out directly to the escrow agent, whereas the termination fee is written out to the seller. So it is not possible to make that one check because they're written out to two different people. So before I get to this next slide, I'm going to go ahead and let you know, if you are not comfortable with this slide, if your broker in charge is not comfortable with this slide, please disregard it. This is not a requirement. This is not a recommendation. This is simply a suggestion of ways that you can maybe alleviate some earnest money issues. One way to eliminate earnest money disputes is to have that earnest money due after the due diligence period. So the way that you would do that is if you look in your contract on paragraph 8, where you have the due diligence section, and you would say due diligence ends, let's say May the 10th. You could then go to paragraph 5, where we handle earnest money, and say earnest money, is say $1,000, $0 accompanies this offer, and $1,000 will be paid no later than 6 p.m. on May 14th. So that way you can tell us, your parties can be aware, we're only going to write one check. We're either writing as a termination fee or we're writing as earnest money. So you could even have the two amounts be the same. Now, this only works if the earnest money is actually turned in on time. So it's not turned in early. It's not turned in late. Because if it's turned in late, the seller can terminate based on the provisions of paragraph 5. If the money is turned in early, you do have a requirement under license law to turn that in within, to the escrow agent within 24 hours. It has to be deposited within 48. So do not have a client who goes, great idea, let me hand you a check and then post date it. That does not work. So this only works if everyone does what they're supposed to do. So you have the proper protocols in place, your broker in charge approves of it, everyone's comfortable with it, and buyers understand when they're going to have to turn in the money. They're not turning it in late, they're not turning it in early. But especially if you have a buyer who's sort of, maybe limited on disposable funds, this may be one way to help. That way you can say you're only writing one check. You're either writing a termination fee or you're writing an earnest money check, assuming that you do everything appropriately and properly. So what do you do if you have a buyer who has a special request? Maybe they have a particular fear of termites, or they want to make sure that they're not going to be any deed restrictions that restrict what they want to do with their property. So again, due diligence is going to allow the buyer to walk for any and all reasons. So one way that you could do this would say be for termites. So this is going to be separate from your CL100, because your CL100 is only valid 30 days out from closing. But say you have a buyer who has previously had a bad experience with termites, or is from a part of the country that is not familiar with termites, and so they have a little bit more hesitation about termites than someone maybe who's more familiar with them. what you could let them know is say, hey, termite inspections are essentially good as of the time they're done, but we can kind of get a sneak peek during your due diligence period. And then if you're not happy with the report, you can simply terminate by delivering notice of termination and the termination fee. Because otherwise, if we wait till the CO 100 and termites are found and the seller agrees to fix them, you do not have the ability to walk away. If termites are found during the CO 100 and you made your contract contingent on CO 100 and the seller refuses to fix the termites, your buyer would be able to walk away without paying a fee. But if the seller does agree to fix those termites, they would have to stick with the contract. You have a buyer who has a particular issue with CCR. So your buyer wants to raise chickens in the backyard. They want to have a giant workshop. They want to be able to park their RV, or there's some particular thing where they're worried about what the covenant's restrictions may say. So SCR Form 391 has a clause at the top that you can attach to the contract, which says the seller has to deliver any relevant covenants and restrictions to the buyer within so many calendar days of the effective date. I'd make that very early on in the contract. I'd make that very early on in the due diligence period. I would then tell my buyer, you need to review these and you need to review these with your attorney. And then before we send our repair request, you're going to give me a thumbs up or thumbs down if you're happy with the covenants or restrictions. What we can't let you do is not look at the covenants restrictions until right before closing. And then you want to try to get out at that point. Once you're outside the due diligence period, your ability to walk away is going to be severely limited. So make sure that you're doing that early on. Again, going back to how many days you need to make your due diligence period, depending on the covenants and restrictions or what other inspections your buyer may want to do, you may have to make that a longer due diligence period than you would normally do. And then, of course, that may have to match up with a larger termination fee than you're used to. I did want to make a brief note on covenants and restrictions, what your role should be as realtors. You guys should not be pulling these at the courthouse. You guys should not be advising on them. You should not be providing copies that you have from a previous transaction. That is the responsibility of the seller to send. And so the seller needs to get those either through their attorney or they need to get them through the property management company. Your entire role when it comes to covenants restrictions as a realtor should be hitting the forward button. From seller, from seller's HOA, from seller's attorney. If you have any questions, talk to your attorney. You should not advise them in any way, shape, or form on covenants and restrictions. A buyer who waits the last minute to submit a repair request. Do not let this be your buyer. The buyer should have requested an extension well in advance of now. If you want to request an extension of the due diligence period, there's two ways you can do it, and it will depend on what your brokerage policy is. The recommended route that I would give is to just do a pen and ink change to scratch out the initial date on the contract for the due diligence period. So we talked about previously May the 10th. Now we need to make it May 15th. Scratch out May 10th, write May 15th, 2022. At both parties initial and date it. That works. If your broker in charge says, I don't like people scratching through the contracts, we need to do it as a separate addendum. And then I would copy the first sentence of the due diligence section verbatim, and then put the appropriate date there and have both parties sign that addendum using Form 390. So, because reminder, this due diligence deadline is an all-in deadline. So at 6 p.m., you're under as-is contract, or you've had to terminate. This is not the deadline. Due diligence deadline is not the deadline to submit your repair request. That's a deadline to be completely done with negotiating repairs. Because in 30 minutes, your buyer's going to have an as-is contract in regards to repairs with this. So if you can't agree to an extension, your buyer may also have to terminate last minute. So you may be telling your buyer, hey, we sent your repair request, but you probably need to be driving to the office at the same time to try to terminate if we can't get that extension signed. Which again is why we want to make sure you build in that 1 to 2 day cushion so you're not panicking at the last minute of what you should do. So I've gotten a couple frequent questions about, well, what do we do about an out-of-town buyer or a buyer without a checkbook? Because you talk all the time about your preferred method for delivering. The termination fee is going to be that buyer bringing the check directly to the listing agent's office. But what do we do if we have an out-of-town buyer or we simply have a buyer without a checkbook? So the first thing you want to do is make sure that you have a plan for getting that termination fee to the seller. When you should find out that your buyer doesn't live in town or your buyer doesn't have a checkbook should not be the last day of the due diligence period. You may need to build in a little extra time into your due diligence timeline. So we talked about that ideal formula, and we talked about 1 or 2 days extra for a local buyer, 3 or 4 for an out-of-town buyer, because you may have to arrange, they may be having to do a wire. So you're going to have to allow for extra time for a wire. They may be trying to FedEx, a check or whatever it may be, and you want to allow for that extra amount of time. If you have a buyer who's from out of town and has a check with them and says, I will not be back in town until after the due diligence period, I don't want to do any sort of online transfers, I don't want to mail anything, I've got a check here and I insist on leaving it with it in the subject in the area that state that we're in. Once again, we do not recommend your brokerage firm hold that. That's when I would reach out to a local law firm and see if they'd be willing to do so. I'm not saying that they will. I'm not saying they're required to. I'm saying that this is something that you should ask. So maybe this is something, there's a law firm that your brokerage does a lot of business with. Maybe start having these discussions if this is something they'd be willing to do for you on a case-by-case basis. Again, you should not take possession of that check ahead of time because that is putting you in liability if something was to go wrong. Now, I've gotten a lot of questions about what if this buyer prefers to do, Cash App or Zelle or PayPal or Venmo. Is that okay? Yes, but you want to make sure that they're sending it to the right parties. So that's where if you have a buyer who doesn't have that checkbook and says, can I just Venmo the money? Go, well, let me check with the listing agent and let the listing agent know, hey, the buyer would prefer to pay the termination fee should they terminate via Venmo. Does your seller have Venmo? If the seller has Venmo, can we get your seller's, ID, name for Venmo, share that with the buyer. Here's what my buyer's name is. And then if we decide to terminate, we're going to arrange a time where we're going to do it. Make sure that we verify before we send that amount of money who the person is, have the seller confirm, then have the seller confirm that they've actually received the money. You don't want to just go, well, hey, how many John Does could there be? And instead of terminating with the seller in South Carolina, you send money to someone sitting in a different state randomly who can't understand why you just sent them $1,000, but is very thankful. All right. Next one would be if there's a power surge that causes the HVAC to be damaged after the due diligence period. So under paragraph 3 of your contract, the seller is required to give you an operable property. So if you kind of think about it, your contract is a default as is contract that can then be amended to include negotiations or repairs. That's all the due diligence period is. It's a time period for the parties to try to negotiate an amendment to the contract in regards to repairs. But without that, or if the buyer never sends a request, the seller never agrees to anything, you have an as-is contract in regards to repair, as-is contract. But that means the seller has to give you essentially the same property that existed at the time of contract, subject to normal wear and tear. So, if lightning causes an HVAC system that was working at the time of contract to no longer work, they do have to get it back in operable condition. If the seller, refuses to do this, then the parties would probably need to negotiate. And if they want to figure out what their legal rights are, then you would need to advise them in writing to talk to their attorney. A buyer who sends multiple repair requests, please do not let this be your buyer. This is a very bad idea. As we've mentioned before, make sure that they're actually sending repair requests on Form 525. That needs to be specific items that need to be repaired. That cannot simply be a request for the seller to do inspections themselves. So you cannot say, seller, please have a plumber come inspect the property and fix any issues the plumber finds. You instead need to send the particular issues your plumber found in their inspection. Make sure you're sending all those requests at one time, because again, once this Form 525 is signed by all parties, the due diligence period is over. So have that conversation with your buyer. Hey, we're about to send this repair request. If the seller was to sign this 30 seconds from now, would you be completely happy moving forward? There's no other repairs you want. There's no other inspections you need. There's no other due diligence you want done. Understand that once this is signed by the seller, if you then try to terminate the contract, it's going to get a lot more hard to do so, and it can be potentially a lot more expensive, a lot more legal liability. So make sure your buyer is completely comfortable with everything that they want done being on that repair request when they send it. And then lastly, what if the parties want it? Hey, they just want an as-is contract. What are a couple ways that they can do this? Should we write in the words as is? You guys should never write in the words as is on the contract. You guys in general should avoid writing in any contingencies yourself. That could be the unauthorized practice of law. I have what's called the punctuation rule. If you're writing anything that requires punctuation, you need to stop, pause, talk to an attorney before doing so. That would include things such as this contract is an as-is contract. This contract is contingent on blank. If you're writing anything about earnest money, hey, this money is non-refundable, or this money becomes hard at this particular date, please stop doing that. That is not allowed. It could be unauthorized practice of law. It's also in direct conflict with license law. So please make sure if you're doing any addendums to the contract, you're having those reviewed and drafted by an attorney. But if the parties want to have an as-is contract, you can actually do that under the current language of due diligence, and so you do not need to amend the contract in any way. So the first way you could do it is just make your due diligence period very short. I don't recommend making it the same day you write the contract offer, because if their contract isn't signed till the next day or something to that effect, now you've got an issue where you've actually got a due diligence period that expired before the contract even began. So what I would do instead is, if we went under contract today on the 28th, I would just have my due diligence period in 6 o'clock tomorrow on the 29th. That's not going to give the buyer enough time to be able to actually do any inspections, but it allows them to sort of sleep on it over the night, and then you don't have to worry about any sort of contract confusion. The other way is you could say, sure, we'll let you do anything you would like, go do any inspections for the time period, sort of in line with our current as-is language that allows the buyer to look around the house for informational purposes only. But say, we're not letting you know up front, we're not planning on fixing anything. And so if you do decide to leave, we're going to require a very high termination fee, because we've sort of warned you ahead of time we're not fixing anything. It's not saying that you can't terminate, but it may cost you more than you would like it to terminate. And then lastly, just remind your buyer that the seller's under no obligation to respond to requests. So if the seller prefers to have an as-is contract, the seller can just refuse to respond to the repair request, and then the buyer is forced to either take the property as is or terminate by delivering that notice of termination and the termination fee. So make sure that your buyer's aware that there's no requirement the seller's going to respond to a repair request. There is no, well, hey, everything I asked for is reasonable. It's only reasonable if the seller agrees and is willing to fix it themselves. So again, just a reminder to you guys, how can you find this presentation? We're going to have it on our Facebook page as well as our YouTube page. Again, I'm not going to be able to provide this slideshow, but if you do have any questions about this, please do reach out to your SR legal staff. We're more than happy to help. The best way to reach us is myself at my email, austin@screaltors.org. Byron King, our general counsel, byron@screaltors.org. Tier Pitts, our director of fair housing policy, tpitts@screaltors.org. Your CEO, Nick Cremitis, nick@screaltors.org, or give us a call on the legal hotline, 803-772-5206. We'll be happy to answer any questions you have from this webinar or questions you had prior to this webinar. That's all the time we have today. I certainly appreciate everyone attending and coming, and hopefully that you found this to be informative and helpful. Again, this will be taking effect June 13th. Anything we can do at SCR to help ease this transition, answer any questions you may have, we're happy to do so. I've still got a few classes left of touring the state, so if I have not been to your local board yet, check with your local AE and see when those classes are. I'm also doing a few local Zoom classes for particular boards. So whatever we can do to help, we're happy to do so. And I appreciate everyone tuning in on this Thursday. Hope everyone has a great day.